In today's video, hello again, I'm going to talk to you a little bit about the Canadian system of justice and about the lawyers who were involved in this case. First of all, some legal terms. Any legal terms that are used throughout the book are explained. I don't think you'll have any difficulty with them, and it just makes it easier as you're reading through the book if you know what they mean. But there are three terms that I think I should just talk about for a minute. And that's the three categories of homicide. The first one, first-degree murder, or murder one, talks about a murder, a killing that is both deliberate and planned. And of course, the lawyers have to prove that it was deliberate and planned so that they will be sure that the charge of murder one is the one that is taken throughout the trial. The second category, murder two, or murder in the second degree, is a death, a killing, a murder that is deliberate, but it's carried out without planning. And the third category, which is called manslaughter, is a homicide that is committed without the intention, now there's that word, intention, without the intention to cause death, though there may have been the intention to cause harm. So that's murder one, murder two, and manslaughter. The Canadian system of justice is called an adversary or adversarial system. It's based on the British system, and in this, each party, whether it's prosecution or defense, has equal opportunity to present their evidence, and one is trying to prove something and the other is trying to prove something else. At all times, though, you have to remember that the people who are accused, or the person who is accused, is innocent until proven guilty. And throughout this case, it was the job of the Crown attorneys, the prosecution, to prove that they were guilty, and it was the job of the defense counsel to prove that they were innocent of the crime. The judge in any of these cases cannot influence the trial in any way. They're not even allowed to comment, except, of course, in terms of legal proceedings. They're not allowed to comment until both sides have presented all their evidence. A little bit of background now about the lawyers involved. And I'm going to start with the defense lawyers. The first lawyer for the defense was Patrick Madden. He was a young lawyer. He had only been 4 years in practice, had been called to the bar in 1970. So since he was relatively inexperienced, he decided to turn to a more senior defense counsel for assistance. Now, Patrick was a solemn young man. He had quite a stern face, which he used effectively in the trial. He had a good reputation as a well-prepared young man. He was ready, and he was a determined spokesman for his clients. The senior lawyer that he had contacted and asked to come and be a part of this trial with him was a man named Eugene Cush. Now, Eugene Cush was a QC, and he had 20 years of experience. He was known as a scrapper and a fighter in court. He was considered sometimes to be a bit devious, but he was a very eloquent defense lawyer, an excellent command of the law and legal cases. Without a doubt, he was the most popular and sought-after defense lawyer in Drumheller and the area. Anybody who was accused of anything wanted to have Eugene Cush to be the fellow who defended him. One of the things that I found most interesting about learning about Eugene Cush was how well he exemplified the words of the famous American defense counsel, Clarence Darrow. So I'd like to read that to you right now. Mr. Cush in particular seemed to have taken Clarence Darrow's description of the role of the defense counsel to heart. To be an effective criminal defense counsel, an attorney must be prepared to be demanding, outrageous, irreverent, blasphemous, a rogue, a renegade, and a hated, isolated, lonely person. Few love a spokesman for the despised and the damned. I think it's important to remember that phrase, few love, because sometimes when you're hearing about a crime that's been committed or a trial, we tend to forget that defense lawyers are doing their job. They may be defending people who are despised and damned, but they're doing their job for their clients. In the trial itself, there was a third defense attorney. His name was Glenn Capling. He was a graduate of the University of Saskatchewan, and he'd been admitted to the bar in 1971. So he only had 3 years of experience, which really wasn't a lot for a murder trial. But he took over for Cush in the trial because Cush became ill. Still, Eugene Cush, QC, remained in an advisory capacity. So that's the defense. For the prosecution, we had 2 attorneys. Robert Ross, QC, was a graduate of UBC, Faculty of Law. He was admitted to the bar in 1962, so that by the time this trial occurred, he had about 12 years of experience. His partner, Gordon Clausa, also a QC, Queen's Counsel, was a graduate of the University of Alberta, and he had graduated in 1966 and had been admitted to the bar in 1967. So he had 7 years of experience. So between the 2 of them, Ross and Clausa, they had about 20 years of experience. By the way, Clausa became a provincial court judge in 1977, and he was only 35 when he became a judge. So he had a great command of the law. I'm going to read a little bit from the book now, and this is an example of the courtroom sparring that I talked about earlier. This takes place when Mr. Capling is in the trial. He took over the examination from Patrick Madden and continued in the same vein. It was obvious that every attempt was being made by the attorneys for the defense to question the voluntariness of Harold's statement by suggesting emotional turmoil. Capling asked, "Did you encourage him to call a lawyer?" Sergeant Ellis replied, "No, sir, other than to point out his rights, and given the possible seriousness, he may wish to have one." Once again, the defense focused on Harold Myrby's mental state, suggesting he was distraught. Once again, Sergeant Ellis said that sad, sullen, and quiet were more accurate descriptions. Capling then asked Ellis to comment on what Constable Lyon was doing, suggesting again that he was guarding the prisoners. Sergeant Ellis replied, "I can't say that he was guarding them. I don't know if they were under arrest or not. Under our normal policy, someone is left with witnesses or accused parties to ensure their safety." Sergeant Ellis thus adroitly avoided the trap set by Capling in the continuing attempts by the defense to show that the Myrbys were under duress. Remember what I said about voluntariness in one of the previous videos. At one point in his questioning, Capling referred to the Myrbys as prisoners, and the Crown Prosecutor commented that, as far as he knew, there were no prisoners involved in this case. Justice Kirby frowned at the defense lawyer, saying that wasn't an advised term. You may hear some extraneous noises in the background, something that sounds like a dog shaking her head and her ears flapping. Well, it is a dog shaking her head with her ears flapping. We have a studio dog here with us today. I'm going to read another short section from the book that deals again with the lawyers as they question witnesses. And this section is about something that's really important in this trial, and that is the stick that Linda Myrby used to beat her child, her daughter. Since the actual statement given by Linda Myrby had been entered as an exhibit, Ross confined his questions to the actions of the police the night of the 27th and the early morning of the 28th. Once more, he made it clear that warnings had been given, explained, and were understood by Linda, that there were no threats or intimidation, and that the statements were freely given. Ross carefully took Sergeant Lauber through what had happened when the policeman had gone with Mrs. Myrby to the house, where she had identified the stick that she had used to beat her daughter. Lauber's evidence supported that given by Sergeant McCausland. The most important statement Lauber made was in regard to the stick. He told Ross, Sergeant McCausland asked her if she would mind going with Corporal Messigers and myself to the residence to attempt to obtain the stick. The sergeant advised her that she didn't have to if she didn't want to. She said it didn't matter. So we went directly to her house. In the basement, she rejected 2 sticks, then picked one up and said, "This looked like the stick." Corporal Messigers photographed it. I then picked it up and initialed it with the time and the date. Ross confirmed with Lauber that there had been no threats or inducements from the police to Linda to take her to the house to show them the stick, and that Mrs. Myrby had appeared to be quite calm throughout the process. I think that's probably enough from the book. I would now like to share with you a quotation from the retired Chief Justice of the Supreme Court of Canada, Beverly McLaughlin, talking about the justice system. She said, "The most advanced justice system in the world is a failure if it does not provide justice to the people it serves." As the reader, you will decide, did the justice system provide justice in Susan's case? Did it or didn't it?